When I first started running, I had all kinds of problems to overcome. I had to work hard to teach myself never to give up. Of course, I need focus and dedication, the ability to set a target and work towards it. Little by little, you reach your goal.
When I'm baking, I'm intrigued by having a problem to solve. The key values that cross over between baking and work are innovation, dedication, and the ability to connect with others. What fascinates me most is how food can bring people together.
For me, it all starts with curiosity. I seek knowledge, then act to provide answers and support. In human rights advocacy, you can't act alone. You need to build a team to help you achieve your goals.
I'm a perfectionist. It's about finding the perfect cup of coffee and learning about what makes it so. And then it's about taking all the information and insight and presenting it to people in a helpful way that is useful for them.
Welcome to Otter Plus. We are the leading equity crowdfunding platform in Malaysia. We assist entrepreneurs with their fundraising efforts by connecting them to investors. Now, anyone can fund your startup. Scan the QR code to work with us. We look forward to hearing from you soon. Thank you and have a wonderful day ahead.
Before she started Eden in Taiwan, she asked herself this question: is it possible for a disabled to experience paradise in a world of indifference? And to her, the answer is yes, it's possible with God. And I share that same aspiration as her, that I know that with God, nothing is impossible for the disabled. So he and his wife, me and my wife Madeleine, so 4 of us, we started this work. And that was in the year 1991.
After 18 years old, they have nowhere to go. So parents send to us, where should the child go? So what we do is we open up this shelter workshop. Over here, we provide training. Training in the sense that basic skill. When they involve in this subcontract work, we are actually giving them a therapy. Therapy in the sense of physical therapy and mental therapy, a mental aspect. So one of it, a company approached us and said, hey, you have any person can do cleaning service. Oh, so this is an opportunity. So we send our staff for training first. The day when you see them, wow, they're able to do something. They're able to be leaders with the other disabled, you know? Or they're able to perform certain things beyond expectation. That is the greatest achievement.
好像你有一大笔钱的话啦，你也不会高兴，但是看在他们生命的那种改变啊，哇，真的很难忘，然后又很感动。我的感受就是说，我每天的话都是在上课，因为我有一班的好老师，我们的生活突然之间的改变，或者是情形我们的肢体方面有一点缺陷，还是说忽然之间我们失去哪一个部分，那我们就觉得这一生已经完了。 其实坦白讲的话呢，我相信上天在我们身上哪一个部位去，就是说他一定会开路给我们。
When we first started Eden, parents asked me, their greatest worry is when they die, who is going to take care of my child? That is one of their greatest worries. So I'm also working towards that goal. And in my many years of working with people with disabilities, I have come to acknowledge that the disability is not the big problem. It's the attitude and the character that is the major problem.
I myself disabled. And today I excel myself because I told myself, nothing is impossible for me. If normal people can do, I also can do, you know. So I want to use my life to serve disabled back, to help them to be independent. We have 77 workers, but out of the 77 workers, 60% are intellectually disabled. So all comes up at 90,000 and solely on public donation. So I would say that the public helps us a lot. You know, I should be thankful, appreciative to sponsors, to donors who have confidence in us that they supported us this week. What the disabled wants is an opportunity, not a sympathy. Give them a chance in life.
Hi everyone. Okay, today we have Professor Steve Ngor, who is actually the founding president of Beihai Asia International Arbitration Center, the first international arbitration center established by Beihai Arbitration Commission in Singapore to focus on disputes arising from China, ASEAN regional trade and investment. By the way, Professor Steve is also the chairman of Arbitration and International Dispute Resolutions of ASEAN Legal Alliance, our co-organizer. How are you today, Professor Steve?
I'm very well, Mr. Fong. Thank you for asking.
We are very honored to have you here because of, I think we have a lot of audience, a lot of participants who are very interested to find out if they have international business. Okay, just in case there are certain disputes, what options they have. And I believe you have prepared a lot of information or presentation for our guests. Is that right?
Yes, I'll do my best to answer most of the key questions that the participants may have.
So for starts, Professor Steve will be sharing his presentations. Then we welcome questions from the audience. Any questions that you would like to consult Professor Steve, please put it in our Q&A or this chat tab inside Hopin itself. Okay, I'll pass it to you, Professor Steve. Feel free to actually explain to the guests now.
Thank you so much, Mr. Fong. Once again, thank you very much for having me here today. How I plan to deal with today's presentation is to deal with it in two parts. The first part is a short or a brief presentation or explanation, and then there will be a Q&A session. So I have learned that in webinars, speakers should try to speak less. I'm speaking for myself only. I can't speak for the rest of the speakers. I'll try to speak as few words as possible, so that will give you more opportunity to ask questions and for interaction purposes. So at the outset, allow me to perhaps provide a synopsis of what today's presentation is all about. What I plan to do is to speak to you plainly and frankly. Why? That is because, as I understand, this is a business conference, not a law conference. So being a business conference, I therefore will be speaking to you directly as business people, users, investors, whatnot. The list goes on. So the idea is to deal with this issue at a grassroots level. And of course, some of you here present may be legally trained or practicing lawyers, but it doesn't matter. And perhaps it will be an interesting session for a refresher, and perhaps for you to share some of your own thoughts later on. So I would begin first by dealing with some of these obvious questions, whether you are a business person, an investor or trader, and so forth. The reality really is that disputes can happen and will happen in the commercial world and trade. We all know there are many sayings out there, one of it being Murphy's Law, that if anything can go wrong, it will go wrong. But speaking of the local culture, or in our localized context, we being Asians, not by means of stereotyping, but rather some of the predominant features of the way we conduct our affairs in life. From my own experience, I have seen that some business people, or many business people, sometimes do not like to talk about things going wrong. So at a courtship, at a contracting stage or negotiation for business, there is a lot of enthusiasm, optimism going forward. But the idea of things going wrong is always at the back of someone's mind, or put in the back burner, because, well, to some extent also in our local culture, it is felt that it is not auspicious to talk about things going wrong. Or sometimes it's just that idea that let's just leave it as it is and deal with it when it comes along. So I'm not necessarily saying that this is a good or a bad practice or habit. It's not for me, not in my place to comment on this. But rather, perhaps at the end of this presentation and with the Q&A, you may have your views about it, and that may change your mind depending on your own circumstances. Put it plainly, as I've always said, the reality is we really cannot avoid disputes completely. We could prevent it to some extent. We could minimize it. It all depends on what business, your primary area of business, what do you get involved in. But to think that things will never go wrong perhaps might be a little bit overly too optimistic. And in the course of my work, there have been people who come to me and complain, or rather being very disappointed or upset about disputes. And so sometimes I say, look, maybe with your business growing and enlarging, and perhaps business disputes come along with it. I don't know whether that is comforting or not, but the fact really is that to think that disputes will never happen in business is something that we have to rethink about that. And having said that, the challenges facing business owners and business people these days are increasingly more, in the sense that when we always talk about small businesses, small and medium enterprises, and as I understand now, we even have expanded the definition now, nano, small, medium enterprises. Again, the reality is we are increasingly doing business cross-border more than before. From my own experience, I can share, for instance, there was many years ago, I was talking about the subject of arbitration in an ASEAN country, and at the end of it, there were practically no questions asked. These were lawyers, and I was curious, and I said, look, have I actually explained myself clear, or simply, do you have any comments or views? And after several minutes of silence, one participant actually very kindly raised his hand and said, we understand what you said. It's just that in my line of work dealing with my clients, none of my clients do business cross-border. And so that was interesting. That was many years ago. But today's situation, I believe, although I've not met this person again, but generally from some of the new seminars or even pre-COVID seminars or even webinars that I have been involved, and I have seen there is a massive development. Now people are talking about cross-border work. And that is because the reality of it is that cross-border work is much more real than we all imagine. And the common example that I always give is that a fruit trader, let's say in where you are in Malaysia, in Singapore, we don't have, I don't think there are any fruit traders, for example. Let's say in Malaysia, you have fruit traders, someone selling durians out of Malaysia. It is a lucrative business, I suppose. Now, just selling durians across the border, even importing, exporting it to, let's say, to China, for example, then technically speaking, you are doing business cross-border. So the point I'm trying to say with this simple illustration is that we are indeed increasingly doing a lot more cross-border work. And that is very much in line with the business environment and climate that we are right now today. Investors, cross-border investors, we have to sell out of the country and we have to buy into the country, import and export therefore. So in short, I guess any decent business people today keen to expand their business cannot ignore the fact that they are doing business cross-border. And when they do business cross-border, then they have to be conscious of the risk that can happen to them. And in this instance, most commonly commercial disputes. Some of these common mistakes that I've seen with business people. So like I said, I'm speaking to you as business people. All of you are business people. I mean no disrespect. It's just from the observations that I have seen the action and reaction and the consequences of certain action that people have taken. In this instance, business people. Some business people, apart from the fact that it is not auspicious to talk about disputes, have also resorted to means of saving costs. And what does it mean by saving costs? For example, they will draft their own contracts, sometimes download it from the internet. Some business people are trained in legal matters or contracts by all means, but still, certain complex transaction requires professional opinion. But there are people who download from the internet thinking that it is the easy way out. There is no need to engage lawyers. Lawyers are expensive, for example. That is the kind of mindset, particularly for small and medium enterprises or businesses. And the cut and paste approach, the common thing, and sometimes also resorting to just trying to save costs. In other words, doing all sorts of means just to save costs. Now, I'm not saying that this is wrong, but neither am I encouraging this as well. Because as I've said, from some of my own personal experiences, and I've seen that there are even contracts of a sizable amount of contract, to me, in my opinion, for a small and medium enterprise, for example, a contract worth about 10 million US dollar, 5 billion US dollar. And I think that is a sizable amount of contract. The value is sizable, right? It's not exactly small. But I have seen also instances whereby people then entering into such a contract, again, as I've said, in my opinion, these are sizable contracts, value of contracts, then they will resort to drafting their own contract. And again, no disrespect, when you draft your own contract, and if you're not familiar with drafting a contract, then you've got to take the risk in what you're written into. And very often they're not. Unfortunately, if it is downloaded from the internet, you can't verify it, and you put things that shouldn't be in there. So sometimes I'm baffled myself because not that the world is in shortage of legal professionals, I guess, and that if people would think that it is important just to save costs in business and by resorting to drafting their own contract. Again, the point is that I'm not here judging people who resort to doing that, but this is where I was saying from earlier on that one have to be very careful about it because there are pitfalls from doing so. But anyhow, sometimes there's also this idea or mistake that people make, thinking that nothing can happen to them. And one of the common things for the more experienced business people that I know of, they will often say that if they are not at the losing end, and they feel that if they will be going to another country and to do certain business, and their thoughts that their position is well secured, then they will often ask me or anyone and say that what could happen to me? What can the overseas party do to me? I mean, they can't sue me. I'm back where I am right now, whether in Singapore or Malaysia, and we'll leave it as it is. What can they do to me? So I will, at the end of this presentation, actually prove to you that that may not be a correct perception, and one might be wrong to think that nothing can happen to them, especially in today's business climate where arbitration is widely used, even though many people may not understand how it actually works and what it means. But believe me, arbitration is far more common than we all could imagine. Again, some of these common misconceptions, again, like I said, I'm dealing with this topic at a grassroots level with business people. And again, there are common misconceptions. Common misconceptions like, well, nothing can happen to me. What will happen to me? I'm a very good business man or woman. I've been doing business for the last 20, 30 years. I can solve all the problems in this world. And that all disputes can be settled. And that, well, all we need to do is to make an offer that one cannot refuse. Well, yes, to some extent, yes, it is all about the dollar and cents to some extent. But of course, sometimes in the business world, as some of us probably can attest to that, it is a far more complex and complicated world than we would imagine it being the case today. Anyway, moving on. In terms of protection for businesses and especially doing business cross-border, it is essential in every contract to have a good or a workable or an operable dispute resolution mechanism. And the dispute resolution mechanism that we commonly see today in cross-border disputes will be ADR, or also known as alternative dispute resolution. And alternative here means it is alternative to going to the courts. We know that that's the most basic thing that comes to people's mind, right? Taking legal action. I'll sue you. Of course, it sounds easy. It's very easy to say. The word sue is only a one syllable, S-U-E, three-letter word. But of course, the reality is that it is much more complicated than that. And so ADR is something that has been invented for a long, long time. And in fact, even in its very natural, ordinary form, like negotiation, mediation, including also arbitration, but I will clarify on that later on. There's a caveat to that. Is that it is the simplest thing that one can think of, that it does not require one to go to the court, to go through a lengthy process, very painful experience, expensive, lengthy process, but to try to engage the other party, to try to resolve the dispute, when dispute happens. And the simplest form, of course, is negotiation. But we know that negotiation is not just exclusive to disputes. People negotiate for business. And of course, in the event of disputes, it is often difficult for two parties who are already in a dispute to try to negotiate with each other. There are a lot of things that goes into it. You will probably know as business people yourself, or if you're a lawyer, the emotions, the unhappiness, the whatnot, the whole litany of issues that you will have that would prevent you from negotiating effectively with a view of achieving an amicable settlement. So for that reason, therefore, there are means of dispute resolution, such as mediation, which is one of the common method of dispute resolution, ADR, that parties resort to, trying to resolve their disputes by way of a structured negotiation. And in this structured negotiation called a mediation, there is a third person, a neutral person, also a disinterested party called a mediator, who is trained to assist parties with dispute. So a mediator's job is trying to help the parties to try to achieve settlement. But ultimately, it is still a voluntary process, and it requires the parties to be able to agree to it. And most importantly, also, must believe in the mediation as a system. But other than mediation, of course, then that's where we move into the much more legal proceedings, a much more legal process. And this is called arbitration. Now, I am conscious that if some of you who are familiar with this term ADR and arbitration will probably know that arbitration is, according to I call it the old textbook definition, arbitration is considered as an alternative dispute resolution method. But I would just like to caution that, because whilst it is alternative to the courts, it is indeed therefore an alternative, one of the alternative methods, but bearing in mind that arbitration is in fact a legal proceeding. And so when it is a legal proceeding, it is no longer entirely voluntary, and that parties who have agreed to submitting their future disputes to arbitration, in other words, if they have agreed to arbitration by way of an arbitration clause in their business contract, they've got to be wary of the fact that it is not a voluntary process where they can choose to participate or not to participate. And it is not, certainly not an ADR, one of the usual conventional ADR method like mediation, where you can simply just ignore a notice of arbitration. Beware and be warned that the moment you receive a notice of arbitration, if of course your contract has an arbitration clause, then you cannot ignore the fact that there is an arbitration. And that if you choose not to participate in arbitration, the arbitration proceedings will proceed without your participation. And unlike in mediation, where the mediator cannot force you to resolve your disputes or to settle your disputes or to come to an amicable settlement, except encouraging counseling, providing counseling and giving that advice to the parties to resolve their disputes. In arbitration, there are actually adjudicators, the arbitrators. They are like judges. In fact, there was a very well-known saying by a senior British judge that used to describe that, where he described that arbitrators and judges are partners in the business of dispensing justice. The judges in the private sector, whereas the arbitrators in the private sector. But anyhow, those are the legal discussion about arbitration. But suffice for you to know as business people that arbitration is certainly not a voluntary process. It is a legal proceeding. And sometimes we need legal proceedings because we know that there is a ceiling to a friendly and amicable negotiation process. Even in mediation, the parties could initiate it, but if one of the parties does not believe in a mediation and does not want to make it work, then you clearly cannot force the parties to settle, to come to an amicable settlement, and therefore to enter into a settlement agreement arising from the mediation. And so it is said that we sometimes need some teeth to it, right? Otherwise, it doesn't bite, right? So legal proceedings are very much in need and still in use today. Arbitration, in particular, been widely used for commercial dispute settlement process by means of a legal proceeding, in addition, of course, to mediation. And why arbitration is widely chosen is also because of its nature, very suitable for cross-border disputes and contracts. And now I will come to that later on shortly, but I'll just meanwhile go through some of these key points. In terms of contracts, of course, in terms of protection, you may have a dispute resolution clause, but again, above all, be wary that you do need a well-drafted contract so that you do have a contract that protects both parties and as well as a contract that works, in short. Right, I'm just get the slide to work. Oh, right. Right. So as I mentioned earlier on, the dispute resolution methods, ADR, such as mediation, negotiation, of course, is there. It's like I say, it's a very natural process that people undertake in trying to resolve their disputes. For certain sectors, for example, like construction industry, you do have adjudication. These are all ADR methods. And then there is the legal proceedings aspect, which is arbitration and litigation. So I mentioned earlier on that arbitration is widely used, and also it is globally enforceable method of dispute resolution because of a treaty or an instrument or a convention called the New York Convention, which is a UN convention on the enforcement and recognition of foreign arbitral awards. The convention simply means that the arbitration decision or arbitration award can be enforced in many countries in the world, or rather in almost all the key economic countries in the world. And it can be enforced as if it is a court decision. Now, how is this arbitration compared to litigation, the difference between arbitration and litigation? So here, for simplicity's sake, that I just mentioned, I just put this stated here as domestic. So what does it mean by domestic? Put simply, litigation is widely used in the domestic or local situation, meaning to say that for one party to sue another party or to take another party to the court or initiating legal action, A and B. Now, in reality, when a party is from a foreign jurisdiction or from another country, from a foreign country, in other words, you could litigate. Nothing precludes you from doing that. But should you obtain a decision in your favor, and put it in layman's term, if you win in the lawsuit, you may have difficulty enforcing it against a foreign party because the foreign party is located in another country. Again, as a very simple illustration, if you sue someone in you are in Malaysia, for example, you are suing another party who is from Burkina Faso in Africa. Now, you succeeded in your claim against this party with a Malaysia court judgment. Could you enforce your Malaysian court judgment in Burkina Faso? The answer is quite likely in the negative. Right? You win, but can you actually enforce it in Burkina Faso? Now, in the case of arbitration, because of the UN Convention, the New York Convention, it allows the parties, the member states, from parties coming from member states of the convention, to enforce the arbitration decision, also called arbitration award, in a member state. So in other words, instead of litigation, instead of suing someone in a Malaysian court, now you are taking someone to arbitration, then you win in this arbitration in layman's term, then you can enforce it in Burkina Faso because Burkina Faso is part of the New York Convention. And this is just a very simple, just the first steps of explaining the benefits or the advantages of arbitration. There are more I will explain later on. It is certainly more than that, and that explains why arbitration is becoming extremely popular these days. Let's take a step back again to look at some of this ADR. And again, this topic here today is not just exclusively about arbitration. And I think I have a duty to also explain to you or to provide you with that understanding of what mediation is and how mediation can work in your situation. First thing first, it enjoys a great extent, a degree of party autonomy, similarly in arbitration and also in mediation. And party autonomy simply means that the parties are in control. So the parties are in control. What does it mean? Now, again, I'm trying to link, your understanding perhaps to situations that you may know, from a layman's term. So we know, for example, that to sue someone in court, to take someone to court, it is a complicated process. There's a process that you cannot be in control once it starts, when it begins. Lawyers are involved. The court will have its own calendar and schedule. The courts may not be able, the judges may not be able to attend to your case at the time that you want it, and so forth. And procedurally, of course, you cannot choose your judge or your judges. So in this instance of party autonomy here means the parties can be in control, can decide many aspects as to how this process takes place. So in the case of mediation, party can decide from the outset whether to mediate or not, whether to choose the place for mediation, for example, or whether to decide on the choice of the mediator, the qualifications of the mediator, the background, the training, the experience. Perhaps a party simply want a clan, a business clan leader, a chamber of commerce leader, a business leader, or a political leader. The list goes on, or in academics and so forth, because the party simply wants someone who is knowledgeable, someone who can help them to come to a settlement. So this is what it means by party autonomy. And of course, beyond that will be in terms of the procedures. Procedurally, how do we do it? Because there is really nothing esoteric in mediation compared to the courts. In the courts, there are legal jargons, there are legal traditions, and so to speak, quote unquote traditions and rituals that you wouldn't understand. But in mediation, simply, it can take place in a hotel room. It could, sorry, not hotel room, a hotel ballroom, or in a hotel, or in any place, any places for that matter. So there is indeed that party autonomy aspects in it, that the parties decide many aspects. And again, as I mentioned earlier on already, some of the features of mediation, it is voluntary and procedurally flexible. It can be low cost because simply the parties may want to try mediation without involving their lawyers first. And they certainly do not need to start preparing. Even if they involve their lawyers, they do not need to get the lawyers to start preparing all the legal documents, the evidence, the pleadings. But the parties can first sit down and try to do a mediation over a day or half a day, you name it. So to try to come to a consensus. And mediation has been proven to be a very good method to try to inject some sense of reality into the parties. Why? Why do I say this? It's because sometimes people get very upset, they get very emotional about disputes, and they thought that they want to, quote and unquote, teach someone a lesson. Or they might be thinking that it is a matter of principle that I want to initiate a legal action. But the reality is, for business people, the quicker they can resolve the disputes, the better. And as well as not destroying friendships and business relationships, because the world is a small place and people still come back and do business with each other. So the list goes on that people may want to salvage that relationship. And that, most importantly, also a very key point is that should you even choose to commence arbitration or to sue someone in court by way of litigation, there is no guarantee that you will win. After spending so much time and money, you may lose, and that so much precious time have been lost. And so mediation, as I said, can inject a sense of reality into people so that they will then understand, and through that process of that mediation process, that structured negotiation, they will come to their senses, and they will realize also with the guidance of a good mediator that it is better off for them to resolve their differences now rather than later. Take, for instance, someone owes you $1 million, and that you will insist $1 million with interest, for example. But these disputes have been going on for months, maybe now a year. Now, you got to tell yourself, do I want to cut my losses, or do I want, and also whether do I want to resolve this in an amicable way as soon as possible so that I can focus on my other businesses and continue with my life. So you may not get $1 million, but to get $600,000 today will be better than for you to drag it out in court or arbitration. And after 2 years, after 3 years, you ended up getting nothing, or you may end up getting much less than you thought. So this is just a very simple illustration. I'm happy to explain that more later on. So also, there is another very important thing about the mediation in terms of a recent development. One of the so-called major disadvantage of mediation is that should both parties come to a settlement in a mediation or following a mediation process, the party will enter into a settlement agreement. Now, they may agree, they may put a signature on the settlement agreement, but what if one of the party fails to adhere to the settlement term? Then in short, the dispute becomes live again, correct? So this is For the longest time, this is what has been said as mediation being the poorer cousin of arbitration. But a major development in recent times with the creation of the Singapore Mediation Convention, also known as Singapore Convention. The convention now effectively means that should the parties enter into a settlement agreement arising from mediation, they can now enforce the agreement as if it is an arbitration decision, or they have the ability to enforce it against the other cross-border. So this is a very important and a major development for mediation with the creation of the Singapore Convention. However, the reality is the Singapore Convention was open for signing in 2019. Many countries were in Singapore countries that signed the convention, but the convention needs to be put into force. They need to be made into law in all these individual countries. And unfortunately, with with COVID, with the pandemic occurring in the early part of the first quarter of 2020, I believe that have actually dampened a lot of initiatives by countries to pursue or to look at any other matters other than public health issues or public health policy. So consequently, we only now have 7+1 countries, 7 countries whereby the Singapore Convention, Mediation Convention has actually entered into force in 7 countries, but with 1 country entry into force for another 1 country next year. So in total, there are only 8 countries. And you could look up the list on the UnSecure website. And out of these 8 countries, these are not major economic trading countries, not India, not China, not United Kingdom, and so forth. So this is a minor setback for the convention. And of course, our hope and aspiration is with the improving business climate and abating pandemic, that more countries will then look into all this necessity to help to boost economy and investment and commerce, and that the Singapore Convention can then be widely accepted. It is highly suitable for SMEs. I don't think I need to go into that much explanation on that, because of the nature of small businesses, the volume of their business or the value of the disputes may not be large. Now, turning to arbitration, again, I'm just going to give you the key salient points of arbitration. Procedurally, it is flexible. There is party autonomy where the parties can decide many aspects of the proceedings, including the selection of the arbitrator. But bearing in mind, again, just opposing mediation and arbitration. Arbitration is a legal process, and you don't see the word here voluntary. So I don't have it here in arbitration, because it is not a voluntary process insofar as the parties have agreed to arbitration. Let me repeat that or rephrase that. As long as the parties have agreed to submitting their future business disputes arbitration and they have that in their business contract, it's no longer a voluntary process. Voluntary as in one of the party saying that I do not care what arbitration is. I think arbitration is a waste of time. I will not participate. We often laugh at that, but there are people who actually made that mistake, having received a notice of arbitration. In other words, an order or a document, a letter telling the party that they are being taken to arbitration. They look at it and say, since it's not a court, it's not litigation in local courts, it's not a lawsuit, I don't care, and that proves to be a very bad decision, a very bad mistake. So it is not voluntary. Therefore you need to understand the extent of arbitration, what it could do for you or what it can also do against you, towards you. It is an independent process in the sense also that the parties can have the flexibility to decide many aspects of the way the arbitration is conducted. That includes, most importantly, the selection of the arbitrators. Most arbitral tribunals comprise of 3 arbitrators. So you could select a legally trained person, a former judge as an arbitrator, and a technical person. Let's say, for example, this involves construction, shipping, investment. You might want to get an accountant, you might get an engineer. So you would have a tribunal comprising of well-qualified people for your disputes. in that particular instance. So one of the common arguments or thoughts about why arbitration is much more advantageous than litigation is also because one of it, not necessarily true, let me just put a disclaimer to that, but generally the case is that judges in courts, in national courts litigation, they are only legally trained. They may not be subject specialists or subject experts. So for example, you may have a complex valuation dispute or relating to tax, then the idea is that a judge is probably less trained in tax matter compared to a tax accountant or a tax expert or even a tax lawyer, for example. Then again, this is not intended to be a sweeping statement. So one has got to be very careful when saying this, but rather this is the general views and the general position, generally being the case. But of course, we know that there are other benefits of arbitration compared to litigation, that is the enforcement of the arbitration decision. So here it is not to compare which is more superior than the other. It is a different mechanism. It's a different creature. It's a different vehicle that is suited for specific purposes. In this instance, for commercial transaction, where arbitration comes in very useful and handy. Other than that, in terms of the procedure, it also allows the party the flexibility to mix and match. The parties can choose the arbitration rules, in other words, the arbitration procedures of certain arbitration institutions, governing law of a country, and choosing to arbitrate in an entirely neutral jurisdiction. So there are advantages of doing that. So for example, why do you want to choose a neutral venue to resolve your disputes? In a very layman's term, I often quote this example. Now, Mr. Fong here, right? Vincent Fong and I, we both have a dispute. And I tell Mr. Fong, come to my house tonight to resolve our disputes. My mother will be our adjudicator. My mother will be the judge of this matter. No matter my mother is the most upright citizen, the fairest person on earth, do you think Mr. Fong will be comfortable with the idea? Certainly not. He would probably, perhaps, most likely prefer that we will go to another place where we can sit down and try to resolve our disputes in a neutral and independent way without the involvement of anyone that might be related to one of us. So generally, that is also the sentiment of people that if they have a dispute, they would not be comfortable with the idea of suing someone in their home country's courts because they're just simply not comfortable with the idea, notwithstanding the fact about the independence of the courts, and that is a separate discussion altogether. But people want that neutrality. They want the independence. They want that assurance. So arbitration provides that, and for that reason, why Singapore is a well-known neutral venue for the conduct of arbitration. In fact, many international arbitration cases being heard in Singapore. These cases do not involve Singapore parties, for example. Now, in the interest of time, let me just move on quite quickly so that we have opportunity or time for Q&A. So I just mentioned about Singapore being a neutral hub, and what we do here is that it is not just Singapore wants to be number one. I don't think that is the intention of Singapore, just wanting to be number one in terms of the ranking of arbitration. I suppose we happen to be able to carve a niche for ourselves. Put it in a humble way. As a Singaporean, we are a small country. We have no natural resources, so we've got to work harder. And one of the things is that we are quite relatively successful at that is in terms of professional services, legal services, and one of them being arbitration. And in the 2021 authoritative report by the Queen Mary University of London report has actually ranked Singapore as the #1 arbitration center in the world alongside London. I'll just move on in the interest of time. And finally, I think we have come to almost the end of the presentation. Before I'll take questions from you, is that to select the methods of dispute resolution, you need to take into account the various factors. Now, mediation will often not be your final recourse. In other words, because mediation is voluntary, what people usually do, and the way it should be done, is to combine mediation and arbitration. So it is like ordering a dessert with your main course. You can't eat your dessert, you might not be full, and your dessert will not solve your hunger pangs, right? So the mediation can be and should be a pre-arbitration or a pre-litigation process, whereby at least it gives the parties an opportunity to sit down and try to resolve their differences, so that they will not be instigated to take up arbitration or to sue someone in court simply because their relatives, their friends, their lawyers tell them to do so. So it gives an opportunity for the parties to take a breather and to call for a time off, to say, let's sit down and mediate. If we cannot, only then we will proceed to the next step, which is either mediation or arbitration. Now, I might have missed out one important point, so I was just fitting through just now. One of the reasons why business people today are also turning to arbitration, if mediation fails, and of course, if amicable settlement doesn't work, is that there are increasingly more avenues to arbitrate. Now, you may be told or are aware that the saying that the discussions or the complaints or the grievances, that arbitration is no longer as quick as before, and it has become very expensive. Now, there is many truths to that, because arbitration is becoming much more complex due to the cross-border nature of businesses and parties these days. And when we talk about cross-border nature these days, we're not talking about many times, with the exception, of course, for SMEs. We're not talking about that $1 million contract. We are probably talking about $100 million contracts. So when that happens, then that is why not only the arbitration is suitable and the way forward, also the risk gets higher. The risk profile is higher, and the parties are exposed to risk of disputes. And when it comes to arbitration these days, there are means to help parties go through arbitration to give them the opportunity to be able to present their case in arbitration or to even participate in arbitration. And by that, I specifically refers to third-party funding. Now, third-party funding is now allowed in jurisdictions like Singapore and in Hong Kong, in this part of the world, whereby parties can obtain financing, loans from third-party funders, litigation funders, that help you to pay your lawyer's fees, pays for your cost of arbitration or the administration cost in arbitration, so that you can then be able to fight against the other party on an even playing field. Rather than, because for a medium enterprise fighting against a big company like a David and Goliath, I do not have the resources, no money to hire top-notch lawyers. The other bigger company will hire the world's best lawyers, whatever that means, the best lawyers to fight you and to drown your case, to extinguish your claim. Then it becomes unfair. So third-party funding allows that now, and it is a very it is new to some extent in Singapore and Hong Kong. But it is increasingly being looked at by parties, given that disputes becoming much more complex and value gets higher these days. And other than that, again, in the interest of time, I just wanted to highlight a couple of points. And these are the things that you should consider them very carefully, either with professional advice or more, self-study, perhaps. Hopefully, you are referring to the accurate and correct information. That is, in the conduct of arbitration, it can be conducted either as an ad hoc arbitration or as an institutional. And institutional arbitration means it will be administered by institutions. What are these institutions? Most commonly, it will be like the ICC, International Chamber of Commerce, the Singapore International Arbitration Center, or SIAC, the AIAC, which is formerly the Kuala Lumpur Regional Center for Arbitration, now ASEAN International Arbitration Center, the American AAA Arbitration Center, the London Court, and of course also the institution that I'm involved with, which is the Beihai Arbitration Center. These institutions provide rules of arbitration, and they administer the disputes for the parties, but they come with a cost, an administration cost. So you need to understand how institutional works and how is that compared to ad hoc arbitration. And in each of these institutions will have its own distinguishing features, some of these institutions offer the content rules that provides for low cost, for expedited procedures, and so forth. So my advice is look up and try to understand and do a bit of comparative and study to understand how this institution works, what they offer, and whether they fit into your needs and requirement. And with that, I also mentioned earlier on that it is important to have an arbitration clause in your contracts, and this is a sample of an arbitration clause. I know I might be contradicting myself a bit by earlier on saying be careful when you do a cut and paste job, but arbitration clauses are commonly cut and paste if you cut the correct thing and you paste the correct thing, of course. And this is an example of an arbitration clause, a model arbitration clause from BNIC, quite similar also with other institutions' rules. Clauses, sorry, and these are some of the key things that need to be in the arbitration contracts, arbitration clause in your contract. So now, in the interest of time, I will then stop now so that you could ask me questions. Otherwise, I'll just go on and on, and it wouldn't be helpful, I suppose, for us to venture into discussing all the legal intricacies of arbitration and mediation. That will perhaps be a discussion for another day. And with that, I thank you for your attention and happy to take questions. Thank you.
Thank you, Professor Steve Ngor. I think there are quite a number of questions while you are presenting. Okay, so it seems that the audience are very keen to understand more about the options.
Yes.
So earlier, there's one question from the audience. As most international agreements state a particular legal jurisdiction, such as Malaysia or Singapore as the prevailing law, can disputes be settled using arbitration as well?
Put simply, Mr. Fong, the dispute resolution clause simply means that the parties states how they want to resolve their disputes. Governing law of the contract means how the substance that governs the substance of the contract. Means the substance of the contract between the two parties will be governed by which system of law. So one has got to be clear what they are looking at. Is that dispute resolution clause or the governing law of the contract? If there is no mention of arbitration, for example, or mediation, no mention of this alternative dispute resolution provision, then quite frankly, that contract cannot be submitted to arbitration, because if the contract merely states Singapore law as the governing law of the contract, that doesn't mean arbitration. And in short, Mr. Fong, for arbitration to be effective, for it to work, both parties must specifically mention arbitration, not anything else, but just arbitration. And it wouldn't work to say that in the event of disputes arising, for example, the parties have agreed to settle their disputes in a very nice, friendly way in Singapore. That is not an arbitration clause. The parties have not agreed to arbitration. That is simply just not an arbitration clause, in short.
I see. All right, there's another question. I think it's something more related to what we are doing now.
Yes.
Can arbitration or mediation be done online?
Oh, yes, I guess, yes, I would say yes, because online is simply a mode. It is a method. It is a vehicle for people to communicate. Of course, in the past, arbitration, mediation, and even court litigation, they have been conducted face-to-face, pre-pandemic. But with the pandemic, we need to find a solution. And online is a method, as I've said. It is a method and it is a vehicle. But of course, there are more to that, in the sense that the general answer would be yes, but of course subject to whether the parties have agreed otherwise, whether the tribunal or the arbitrators can agree to it, and so forth. But in short, speaking of a method, a medium, or a vehicle, my answer is yes, it certainly can be done online, and it has been done that way throughout the pandemic period last year and also this year.
I see. Well, I've just one more questions coming in.
Yes.
What will be the cost that we are looking at for an arbitration? Just a general one.
Yes, of course. That is a very relevant question. I guess all business people need to know that, when disputes happen. So there are the administration costs, the central administration fees, if it is an institutional arbitration. center administration fees, and the arbitrators need to be paid professional fees because they are your private judges, right? So the most important fee you need to pay, the institution that handles or administers your case, whether it's RCC, SIAC, AIAC, or even BIAC, they will charge an administration fees, and then you have to pay the arbitrators fees. That is the two key costs. Now, you also need to pay your lawyers. Most likely you engage lawyers. If you engage lawyers, you need to pay your lawyers. And finally, there will be expenses incurred. So these expenses involves, for example, hearing venues, a hearing room, for example. In Singapore, we have the Maxwell Chambers, a place where you can hire for hearing. In Malaysia, in Kuala Lumpur, you have the Sulaiman building, where it is a dedicated complex for the handling of arbitration. So there are these ancillary costs, Mr. Fong. So again, the two key costs, expenses involve administration fees, arbitrators fees, and of course you have to pay your lawyers and the other expenses.
Okay, I think that so far, Vivian actually congratulates Professor Steve Ngor for such a great presentations. And I think we have also got a number of your friends who actually sign in and say hello to you.
Right.
And, yes. So, okay, just to wrap up for the day, this is something new for a lot of business owners. At least it's new for me. So now I understand that if I actually conduct international this agreement, I mean sign an international agreement, especially cross borders, it's a much better idea to have it on the third party location like Singapore. Let's say if I'm trading in China, to have it specify in the agreement that, okay, we are adopting the arbitration in Singapore. This will give the impartiality and the confidence that if there's certain dispute coming up, then we have a trustworthy third party to look into it. Okay.
Indeed, Mr. Fong, if you don't mind me just to add on to add on a point to what you just said, which is a very valuable point that you raised, is that the choice of the place of arbitration or the juridical state of arbitration, you are right. Yeah, and as I've mentioned earlier on, that people would prefer to choose a neutral third party venue. But having said that, parties can end up choosing a venue where it is the home country of one of the parties. Now, that is a question of the negotiation process in the formation of the contract, of course. Maybe, and there are also other reasons, that various other factors that is to be taken into account. But having said that, even if, let's just put it into context, like Mr. Fong, you are in Malaysia. You're in Malaysia, right, Mr. Fong?
Yes,
you're in Malaysia. I am in Singapore. For some reason, I managed to persuade you to choose Singapore. I'm a Singaporean party. I managed to persuade you to put Singapore as a place of arbitration. Now, does it mean that Mr. Fong will be severely disadvantaged? The answer is no, because arbitration certainly retains a very high degree of independence. And in that, one of the basic mechanism of arbitration is that, Mr. Fong, you get to choose the arbitrator. No, let me just clarify that for in the interest of lay people. You have some say in the criteria, the requirements, the qualification, or the background of the arbitrator. So you could choose, you could put forward a criteria, you could appoint an arbitrator that you think will fit into your criteria and your temperament. And therefore you do have that degree of some say in how the arbitration tribunal is constituted, rather than in instances whereby again, it's not to put down court litigation system. In court, you don't get to choose the judges. It is assigned to you. They are public officials, they are civil servants, they are judiciary officers. They are appointed for you. You don't get to choose, you don't get to decide. By the arbitration, you do have some say. So while the venue is important, but you will not be severely disadvantaged because there are means for you to safeguard your interests at the end of the day.
Thank you, Professor Simo. I think this is very important. I hope that I hope that this session is actually longer, maybe 1.5 hours. I'm sure there are more questions that a lot of business owners would love to understand more. But we thank you for your precious time and your very insightful presentations about the arbitrations and mediations. By the way, your sessions will be replayed tonight at, let me see, 7 o'clock in the evening again. So for those who miss these sessions, the front part, you can tune in again at 7 o'clock and Professor Steve Ngor will go through the presentation again because it's a replay.
So
thanks a lot. And by the
Simon.
way, I would like to actually let everyone know that we have another sessions about investment migrations for Thailand at 6:15. Okay, that's about 15 minutes to go. And then we also have a very interesting sessions at 7:30 this evening, Malaysian time or Singapore time, called Business Investment and Property Investment Opportunity into the Midwest United States of America. Okay, so we have 3 very qualified speakers. First of all, Vicky Silvano from Chicago Association of Realtors to talk about property investment in Chicago. Then we have Mr. Carl Schultz of World Business Chicago about business investment. And finally, we have Dato Sri Matthew Yeo, who is the principal of the American Group. Okay, so basically, if you are interested in to know about investment in both business or property, as well as whether you can get a green card in United States, tune in at 7:30 tonight. Okay, I'll be tuning in. Okay, thanks a lot again, Professor Steve Ngor.
Thank you so much.
Okay,
Thank you for having
stay
me.
safe
Thank
and
you.
stay healthy.
To you too.
Bye-bye.
Thank you. Bye-bye.